It's 2026, and the Texas race for U.S. Senate has become about more than policy. Democrat James Tellerico has made the impeachment of Attorney General Ken Paxton a defining issue of his campaign. More specifically, what to infer from the accusations, impeachment, and acquittal. That's exactly why we provide State of Doubt, a documentary series about the Paxton impeachment that examines the evidence, the record, and the questions that still don't have clear answers. We're not here to tell you what to think or who to vote for. We're here to give you the inside story, because reasonable people, looking at the same facts, have reached very different conclusions. For example, here's a little backstory that often gets overlooked. In May 2023, just 3 days, only 3 days, after Attorney General Ken Paxton publicly called on the Republican Speaker of the Texas House to resign, alleging the Speaker had appeared intoxicated on the House floor, the Texas House voted to impeach him. The vote was 121 to 23. There were just 4 hours of debate. The Texas House of Representatives impeached the Texas Attorney General after just 4 hours of debate. And keep in mind that many of those who voted to impeach were Republicans. The allegations against Paxton didn't come from political opponents. They came from senior members of his own staff, people who worked alongside him every day. They filed a formal complaint with law enforcement. But here's something that rarely gets mentioned. At the Senate trial, they testified they offered no direct evidence of wrongdoing when they made the referral. Here's the legal context that matters. Under Texas Government Code, Chapter 554, the Texas Whistleblower Act, a public employee is only protected from being fired if they formally report a violation of law to an appropriate authority. No report, no protection. And critically, Texas law carries no penalty for filing a false report. What the trial record also shows is this. The whistleblowers admitted, under oath, that they feared Paxton was going to fire them as early as August and September of 2020, months before any formal complaint was ever filed. So here is the central question. Did the whistleblowers come forward because they genuinely believed malfeasance had occurred, or did they file a report because they feared being fired, and the Whistleblower Act was the only legal protection available to them? That question matters because of what came next. The whistleblowers filed a retaliation lawsuit against the Office of the Attorney General, not against Paxton personally. But as the Attorney General, he has the authority and agreed to a settlement, $3.3 million. But there was a catch. That settlement needed to be authorized by the state legislature. The whistleblowers needed the Texas House to approve the settlement funds, and when the whistleblowers made their case to House members, the very people who would vote on both the settlement and the impeachment, they did so without being placed under oath. No sworn testimony, no penalty for perjury. The whistleblowers were, in effect, asking legislators to hand over $3.3 million of taxpayer money with no legal obligation to tell the truth. Whether the whistleblowers embellished their accounts to make the strongest possible case for the immediate settlement, we can't know for certain. But we can say this. They had every incentive to embellish their case, painting the Attorney General in the worst possible light under the legal theory that if you don't agree to this settlement now, it could get a lot more expensive if we go to trial. And without being under oath, there was no legal consequence if they did color their conversations with House members. That's not an accusation. It's a structural reality. How much weight you give their account, knowing that context, is something reasonable people answer very differently. Then came the Senate trial. In September 2023, the Texas Senate took up the impeachment as the final finders of fact. This time, the whistleblowers testified under oath, subject to the penalty of perjury. After 9 days of trial and 8 hours of deliberation, the Senate reached a verdict. Ken Paxton was fully and completely exonerated and acquitted on all articles. The Texas Senate, like the House, is controlled by Republicans, and they came to the completely opposite conclusion. Here is what is not in dispute. The House voted 121 to 23 to impeach. The Senate acquitted on all counts. Senior staff filed formal complaints under the Texas Whistleblower Act. Trial testimony confirms those same staffers feared being fired months before any report was filed. The Whistleblower Act requires only a good faith report of a legal violation to trigger its protections, with no consequences for filing a false report. and Paxton was never charged with any wrongdoing as a result of the whistleblower's referral. In fact, Ken Paxton has never been convicted or admitted to any crime or corruption. What is in dispute is what those facts mean. What can be reasonably inferred? Were the complaints an act of courage or an act of self-preservation? Perhaps possibly even a little of both. Reasonable people looking at the same record have reached completely different conclusions. That's where the doubt comes in. State of Doubt doesn't tell you what to decide. It's designed to give you the inside story you need to decide for yourself. The law, the testimony, the votes, the competing interpretations. Watch the full docuseries. Look at the evidence. Ask the hard questions. Because in a democracy, an informed vote is the most powerful thing you have.